Hi, everybody. Thanks very much to everybody for joining us tonight. We have it's great to see this strong turnout for what's going to be a fascinating discussion. My name is Michael Karnikolas. I'm a newly minted associate professor here, as well as the Palmer Chair in Public Policy and the Law. And I'm delighted to welcome you all to the latest in our Tech Talk series from the Law and Technology Institute on AI and the practice of law. It's great to see the turnout is so strong. We are planning more of these discussions by the Law and Technology Institute and on areas that are of relevance to the intersection of law and new technologies. From that perspective, we enormously appreciate any support to continue this work. And so there's a QR code behind me. Donations to Law and Technology Institute are enormously appreciated as we seek to build and expand technology programming here. And on a similar note, I want to start off by offering my thanks to Stuart McKelvey and Tories LLP for their sponsorship of this event, as well as Dalhousie's Next Wave Fund for supporting the Tech Talks series. Okay, that's the spiel that I needed to do. I'm happy to jump right into the substance of it now with our first panel on how AI is impacting the practice of law. We have three fantastic panelists. Carla Swansburg is the CEO of ClearyX. Jane Bates is Counsel and Practice Innovation Leader at Cox & Palmer Halifax. And Anthony Rosborough is an Assistant Professor of Law and Computer Science here. And our moderator, Kethy Lynn, is a 2L in the JD MBA program, as well as a research assistant with the Law and Technology Institute. Kethy, over to you.
Hi, everyone. Thank you all for joining us, and thank you to our panelists as well. I'll just get this started then. So first, would you be able to introduce yourself and share some information about your role and thoughts of the impact of AI in the legal profession?
The first big question is who goes first? So I'm Carla, and as you heard, I'm the CEO of ClearyX. ClearyX is a small kind of startup business that's owned by a major global law firm, Cleary Gottlieb, based in the US. We're a fully remote business. We're about 30 people. And our job is that the law firm invested in building this separate business in order for us to figure out how to disrupt their business. So we are essentially the kind of related business that is setting out to figure out how to use technology to transform legal services and to try and figure out what parts of the commercial law we can pull from the firm and move over to new models. I graduated from this law school well over 30 years ago. And people will often say, well, how did you get into this area? I actually lived through the kind of transition from legal research in books and paper parts to online legal research. And then as a litigator in practice, I lived through banker's boxes and sticky notes to e-discovery. So I've actually personally seen and experienced the transformative power of technology to take away all the stuff nobody went to law school to do. So whether I was a lazy lawyer or an ambitious lawyer, you could decide. But about 10 years ago, I'd say, I did a theater degree next door, and then I moved over here and did a law degree. And then I moved to Toronto, but I also went back and did an MBA and spent some time after I worked as a private practitioner in-house at the Royal Bank of Canada for about 7 years before, during, and after the financial crisis, which was another transformative time in terms of the business of law. So fast forward to now, I am building this business fully remote. We're global, plan world domination, plan to have partners of the firm report to us within about 10 years. So over to you.
So I'm Jane Bates. I am Counsel and Practice Innovation Leader at Cox & Palmer. I have a hybrid role. I practice client-facing half of the time. I'm a technology lawyer by trade. I explain to people that what do I do for a living? I write those contracts that nobody reads. So that's my specialty. My interest in innovation came from spending 15 years in-house in high-tech industries before transitioning over to private practice. Certainly my accent obviously is not from here, it's from Australia. Australia is one of the leaders in legal tech, probably mostly because of the lack of regulation there. So, that encourages innovation and the ability to do things a little bit differently. So when I moved to Canada some 6 years ago, I was a little bit in shock and awe at some of the things I had gotten used to we weren't yet doing here in Atlantic Canada. So in addition to my client-facing role, doing innovation for the firm, so I'm the first that gets to play with any of the legal tech that comes in. I also get to embrace it in my practice and actually trial it in a working lawyer capacity, which is fun. I work within the organization explaining to the lawyers why they really need to be embracing change and jumping on this technology bandwagon, and it's not at all as scary or as risky as some early case law with lawyers that didn't do their job properly might have led some to believe. And that is fun. And I think the biggest challenge facing me and the profession in the adoption of technology, certainly from a private practice perspective, is kind of the antiquated ways that we bill clients on an hourly model, and the fact that that doesn't particularly encourage doing things faster or quicker or more efficiently. So that is that's the challenge ahead, I see.
Thanks. I'm Anthony Rosborough. I'm an assistant professor of law and computer science. My teaching is kind of in the intersection of intellectual property and law and technology. I'm also developing, quite slowly, this new course in law and technological competence for lawyers. So my work, obviously my teaching and my research kind of is on both sides of the street, and those are sometimes two worlds that are difficult to make sense of in one job, but that is my task. And Carla's laughing because she understands the difficulty on her end. So my research is really focused on the right to repair and the nature of innovation and how law can either support with incentives and rewards. And with that, I guess my sort of orientation to the issue of legal technology comes from a perspective of the computers break and the computers are imperfect and humans are often called to the rescue to fix them. So that's kind of my overarching perspective on the role of AI in the legal profession, and I'm honored to be on the panel.
Thank you. So given the rapid rise of AI and legal innovation in general, in what areas of legal practice do you see AI making the most jumps, the most changes, and what other areas do you see AI not affecting these practices at all?
I think every area of practice, every subject matter is going to be affected in some way or other. I think I alluded to some of the things, the sort of practice things like research and discovery that have already been transformed, and perhaps there's less to be gained, and that the advances from AI will be probably more incremental. But a lot of the work that our company does is in commercial law, M&A, diligence, contract management, and contract analysis. And in all of those areas, there's a significant lift. It still amazes me that there are associates from some of the largest law firms in the world who haven't used technology to do review of thousands of contracts yet. And we find these technologies, even just using something like sort of natural language processing, machine learning, is cutting about half the time, 60 to 70% of the traditional costs of doing that work. So I think that area of kind of corporate commercial law is kind of a huge one. The AI tools themselves, I think, and again, I keep referring to this, but having learned that these things take some time to build the trust for people to use them in their practice, that I think we'll always have a human in the loop, but I think we're just at the beginning of the transition where people will start to rely a little bit more on artificial intelligence to do the initial stages of work. So that's sort of no worries at all, but first year lawyer work, for example. We can come back to that point, but I think there's no area that won't be somewhat transformed, and that there's just some low-hanging fruit in areas that have been historically less affected.
Absolutely, I certainly agree with that. I'd say 5 years ago we were talking about robots going to replace lawyers, and now actually having had the ability to see that landscape and what's shifted dramatically in the last few years, my answer is no, no robots won't replace lawyers, but lawyers that know how to use AI and other legal tech will certainly replace lawyers that don't know how to use it. So, we really need to jump on board, because this train is in no way slowing down, and the technology gets better and better as we go. So we're certainly seeing, I would echo, in commercial law, business law, we're seeing a lot of new technology coming out that is either trained on kind of generic models, whether it's kind of OpenAI or one of the bigger platforms. But we are seeing a lot of movement and progress in things like contract drafting, contract redlining and review, document drafting, the ability to use it in something like an M&A transaction for due diligence, where I was also in the sticky note era, and nobody wants to wade through a box of paper when you can digitize it and have technology doing that. Now, that's not to say that the output is 100% and that you don't need to still do the work. You absolutely do. But as a first pass, it's as good as, I don't want to say this, the first year lawyer. So that is the reality. So in addition to kind of the legal specific tools, I would say, what are people going to jump on the most? Really quick wins, like using AI within the administrative functions of any organization, process improvement, translation of documents, minute taking. I can't tell you how much I hate taking minutes. And the fact that there's technology that can do a reasonable job at that is great. These are things from a private practice perspective I can't charge clients for. So the quicker I can do it, the better it is, certainly for me. So, the embracing the technology to be able to use AI and innovation to cut down that administrative non-billing work is certainly being well received and adopted, while the profession struggles to catch up with the disconnect between how things are charged and how people want to pay for legal services.
Yeah, I think when we ask the question, where can AI have the biggest impact, we need to kind of ask ourselves what AI kind of is under the hood, right? What is beneath those two letters and the gloss? And ultimately, it is advanced computational statistics. Right? It's finding the most likely answer to a problem. And so, what is that good for, right? And I think Harry Frankfurt, who's a philosopher in the U.S., wrote a book quite a few years ago called On Bullshit. And that book, it's a provocative title, right? But what Frankfurt was saying is essentially there's a difference between bullshit and lying, right? In the sense that lying, in order to lie, you have to know what the truth is. And you take a deliberate attempt to evade what the truth is. But bullshitting is worse than lying, because it's an attempt to persuade without regard for the truth. Right? And so bullshit is more dangerous in society than lying, because it has no regard for truth whatsoever. And so I think where AI has the potential to have the most impact is where the outputs of these systems, the truth does not matter. And where does that come into play? Well, the first draft of a document, reviewing something and analyzing something. The truth of that doesn't necessarily matter. Now it may. So I think we need to sort of peel back the gloss on what we're talking about with AI and ask fundamentally what it is doing in terms of statistical probability. Because I believe personally that law is a subdomain of the humanities and not of statistics and math. And I think we all, as lawyers, have some role to play in ensuring that remains the truth. That remains the case going forward.
I think, too, that in addition to how it's going to change specific practices, another important question is how is this going to change how you practice and the business of law? And I think you alluded to the pricing thing. We're still in an hourly rate. I mean, we've created a whole business that's not hourly, because to your point, as you get better and more efficient, I remember the first time trying to pitch a technology that was going to cost $100,000 and pitching to the executive committee that the immediate impact would be they'd bill 50% less hours. And that's not a compelling business case. But in some ways, it's starting to transform not just kind of how you practice, but what you can do. So in addition to things like pricing and how lawyers will have to run their business and capture the value, we're seeing things, and I'll give you a sort of interesting recent example. It was not my idea. It was the idea of one of the partners we work with at the firm who said, let's look at the Edgar filing, so the public securities documents that have been filed. And there are a couple of partners at other law firms that often come up in a certain kind of really complicated public company deal. And what he asked if we could do was figure out the sort of 10 most contentious things that come up in negotiating the documents and use sentiment analysis and AI to determine what that lawyer has said, that opposing counsel has said on those points. So when he drafts the document against that opposing partner, he can put language that that lawyer has drafted, and he can pitch in his document so that, obviously, we're all people, the lawyer reading that is going to go like, oh, that's a really good clause that dude has drafted. And it actually can change the dynamic, I think, of that negotiation. So there are some cool things, and predictive analytics and outcomes of litigation are another example that lawyers just couldn't do before, that I think are going to kind of augment get rid of the boring stuff that we used to have to do and start doing these other kind of cool analysis. So that's I think, a fun thing.
Yeah, I think that like a lot of legal practice is improvisational, and it's kind of ad hoc, right? And I think those are the areas where we're least likely to see numerics come to the rescue, right? That like a lot of the way a settlement negotiation goes often is a lot of kind of human emotion, and dealing with clients is really difficult to turn into statistical probabilities. I mean, maybe on a massive scale it is, but on a reduced to one particular client issue, it's really difficult to turn that into math, right? And so I think those are the areas where we're likely to see AI not have much of a role. But, yeah.
Particularly the client-facing, the family law, criminal law, those
Right.
kind of things that needs the human touch quite heavily. We will see less impact in that.
Those are some really insightful answers, and I'm glad to see AI is, largely positive in its impact. But what about legal work, which involves really highly confidential information? What precautions should firms and lawyers and legal departments take when using these AI-powered tools?
Do you want to start? Yeah. Do you want to
That's
talk
a good
about
question.
tech competency?
Well, so confidentiality, I suppose, being one dimension of that, privacy being another. But I think that requires, that's assuming that we're always aware when we're using an AI tool. And as of right now, a lot of these platforms, it's very obvious based on the interface. It's a web browser. It looks a certain way. But increasingly, these tools are being integrated into commonplace tools, where I think Adobe Acrobat, of all things, has now an AI assistant. I don't even know what use that could possibly be. But, just to show you that, to borrow from Bianca Wiley, who's a person I respect quite highly, she's analogized AI to kind of like asbestos, where it's in a lot of things, but we're not quite sure where it is. But and so I apologize for the negative characterization for those who are very adamant about this technology. But what that says is that we lose the ability to know where it is and how we need to respond to it. So I think the risk there is not so much. The answer is simple, right? Don't put client information into the AI, right? Simple answer. But then in practice, how do you operationalize that when Microsoft Word and Bing and everything else has some sort of AI integration? It becomes really difficult because now it's just kind of woven into everything. But that's my response.
I think we've come a long way, even in the couple of years since ChatGPT was launched, because initially any queries that you put in got sort of sucked back into the master sort of training database for the LLM, and there were famous cases where I think it was either Sony or Samsung. They put some code in, and suddenly your code's not private anymore. And there are now enterprise terms of use for some of these LLMs where you can sort of isolate it in your server, and the queries go out but don't stay there. They immediately don't get deleted and are just used for the purposes of recalling the information. So the systems and infrastructure themselves have gotten a lot better. And I think we've all learned from, the Mata Avianca case in the US that you probably should not just ask ChatGPT for case law. I actually got an NDA from someone the other day to review, and I don't know if you've used ChatGPT in a way that you see the little borders around the text,
yeah.
and so it's so easy to tell someone who used it. But trust but verify, and I think we've learned a lot in those couple of years about that sort of thing. Humans in the loop, I think, are going to remain important for anything that needs to be right versus just bullshit. It's going to remain even more important. Creative writing, that's one thing. Analyzing a contract, that's another. And then there's a ton from local regulators to UNESCO to the sort of EU of guidance, right, about bias and explainability and transparency and confidentiality. So lots of much smarter people than me have created these frameworks for that. For us, it distills down to, do the clients want it or not want it? And if they want it, are they aware of the potential risks? And are we taking the sort of infrastructure, InfoSec steps to kind of isolate the data? About a year and a half ago, we had a couple of clients who wrote letters when ChatGPT was like all the rage, saying, don't use this in my work. Don't you dare use this. And then over the last year, we've started to get letters from clients saying, explain to me how you're using this to provide value to me. So it's happening fast.
Yeah, that discussion is certainly changing. What I would say is whenever embarking on the endeavor of using AI, you need to be considering, what do the professional rules say about what you have to do? That's incredibly important, and I'll leave Jonathan to talk about that. But, what do your clients say? Clients range, and the courts as well. What are the court directives around, can you use AI and can you not? And what you hear from clients in the courts and, general layperson varies significantly depending, frankly, on their level of education on AI and their understanding of what it means. From, oh no, I've heard the news that this is unreliable and absolutely you can never use it, to, you can use it, but you've got to tell me all the prompts that you use, which, doesn't really reflect the reality that, anything that you're using AI on is an iterative process, and you shouldn't just type in one prompt and take the answer out as gospel. That's just not how it works. To clients and courts that understand, you are a professional as a lawyer, you need to stand behind what you're providing, regardless of whether you've used technology or not. And kind of that's the leaning that I lean towards is, if I use AI in my practice, that's not a get out of jail free card. I can't say, oh, well, I got rubbish responses from AI. Professionally, I need to be competent and I need to stand by whatever gets presented to a client. And I think that the discussion around that varies quite significantly depending on who you're speaking to. I'd also say, if you're using an AI tool, understand what the terms of use are around that. There's some really weird things in some that are publicly available. Free Gen AI tools. Let's just safely assume that if it's free, they're probably using your data to train the algorithm, and you cannot assume any kind of confidentiality. But look at that, understand, who owns the output, what's happening with the intellectual property rights. Are there restrictions on what you can use it for? Most of them now say, don't use it for medical purposes or don't make it for legal decisions and things like that. But there are some really random other things you can't use it for, like politics and lobbying and other weird stuff like that. So, buyer beware is, I guess, the thing that needs to be said when you're using this technology.
Thank you. You've all mentioned the importance of being a technologically enabled lawyer in the future. And so for us law students and junior associates, how can we responsibly use AI for research without the risk of over-relying on it? Or what should we keep in mind when we're using these tools?
I'll say understand its limitations.
Yeah, I think this sort of trust but verify, but also just getting familiar with it. Before ChatGPT GPT was publicly launched, one of our external advisors is the Global VP of Public Policy, and she gave us access via a sandbox. And our approach was just play with it in a safe space, like, you know, the creative stuff, and don't put client data in it, and get comfortable and familiar with the capabilities. Because I think it will be critical to do that. And then just, you know, whatever the context is in which you're using it. And we do still have some of the early guidance, as you said, was courts, like the first one out of Texas, don't use any AI. And you're like, should I go back to books for legal research? Should I go back to banker's boxes? So
Shall I write letters on my typewriter?
That's right. You can't not understand at some level how, you know, not necessarily how it works under the hood entirely, but, you know, how to use it and how to engage with. So I think just educating yourself, there's so much, and we've got our entire team doing some prompting free classes, or, you know, maybe not free entirely, but there's a lot of information out there. And wherever you end up working, chances are they'll have some guidance or some supports available, and if not, you know, I bet the Fair Society does, and others. So responsible use, know what you need to know what you don't know.
Yeah, so sorry, go ahead.
There you go.
I was going to say, I think, so the question was a little bit about like over-reliance, right? Over-reliance on it, and how do you know when you're over-relying on it? That's really tough to know when you're over-relying on it. And I think maybe one aspect of teaching students and young lawyers to detect their reliance might be to occasionally, and I'm not saying to do this on client time, but to occasionally like go back to maybe an unassisted approach to solving a legal problem, and to familiarize what it feels like once again to have to do something without the assistance of AI, so that you're then able to detect how much it is then filling in the gaps for you. Because, for example, like, you know, my wife Hannah teaches legal research in the law school here, and we always talk about this experience that I had when I was a young lawyer. I could never understand, in terms of my articling year, really like how statutory revisions work, right? Like, never really made sense to me what that actually means. And then I went to the barrister's library, and staff there showed me all of the annual statutes, and I picked them up and I looked at the revision, and somehow that like tactical engagement with it actually taught me what all of that means. That, sorry Hannah, that in LRW it didn't ever make sense to me. And so I think in much the same way, like to understand what, like how AI is assisting you and where to have your, like where your blind spots are, might be to occasionally not use it in your training, so that you can sort of develop that muscle.
And none of us would have ever gone to a textbook and copied word for word a paragraph from the textbook, because that's plagiarism. And in some ways it's the same, right? You're getting some general knowledge and information if you're using it for research. Again, the validity of what you're finding, and for our kind of work, especially if you're doing something like a diligence review, the provenance of the answer. Can I find the citation? In case law, can I find the citation? It's still pretty important.
And you'll see with the more advanced tools that they will actually refer back to the source of the information that they provided you. And if they're not, then I'd start to ask some questions about how reliable that is. You know, you always need to validate the information and the output that AI is spitting out against authorized sources, whether that's Lexis or Thomson Reuters or whatever it might be. Going back to the case law, you know, don't be the lawyer that presents something in court with a handful of hallucinated cases. It's not a good career move, by the way. But you know, just understanding that, you know, I certainly encourage, when I trial technology, I will get it to provide an output. Say I've done a contract review on something previously, I'll get the technology to do it. And then, you know, was there anything that I missed? And what's all this other random stuff that's, you know, I never would have picked up because it's not relevant or it's not appropriate. I think the challenge for new lawyers entering into the profession is that they don't have that history of learning and understanding. That's not relevant. I don't need to worry about that. So a lot of the things that, you know, AI picks up, you know, false positive, whatever it might be, you know, that's harder for new lawyers to understand, and it's much easier for more experienced practitioners to look at an output from AI and you know, straight away see that's on the money, or that's, you know, what was it thinking? Maybe I won't be using this at all. So that's the challenge I see.
One of the best phrases I've heard for this is that you use AI like a drunk uses a lamppost for support, not illumination.
What's the? Somebody has called it that AI is mansplaining for something. But you know, that's a reasonable summary because it. No offense, men, but you know, it gives you an answer and it's so confident in it, and it will tell you about how right the answer is, and you really should be convinced by this answer. But the reality is that's just the way that the models work, and don't rely on the confidence that you are seeing there.
And that sounds like an attempt to
Bullshit.
persuade without the truth, right? Yeah, you know, and I think like if we think about how algorithms and large data sets work, is they tend to produce monocultures. Like I'm sure we all have this like the Spotify effect, where we all end up somehow listening to the same playlist that was tailored for our individual tastes. We're all listening to the same thing somehow, and I'm sort of fearful a little bit that like that you know certain legal issues in terms of stare decisis and legal research that you know. That only 3 cases will ever be cited on this issue once again, because we'll lose the nuance, like we'll lose the ability to actually do the difficult task, right, of sorting through the different dissenting opinions to figure out the line of reasoning. That because it's given to us right away, that we'll kind of have that legal monoculture is maybe a risk as well.
But I think one thing to mention, and you know, we probably don't talk about it enough, we've now got this wealth of information available to us. And I do feel an element of sympathy for judges nowadays who are presented with, you know, 4,000 mostly irrelevant case citations, because that's what gets spat out, and the impact that has on their ability to wade through and, you know, formulate judgment and case law precedent from that. You know, it's a difficult environment now for them to be practicing in.
But in some ways that suggests that your role as lawyers is going to be at least as important, if not more important, because you will need to be the voice that parses through all the noise and gets to the judgment piece. And that's not going to change. It might be made harder because there's too much information there.
I'm definitely going to take a few of those pointers as I write my first legal memorandum with Hannah there. But for lawyers and law students who are unfamiliar with AI, what's the best way to start becoming more technologically adept and sophisticated, and how can law schools do a better job of imparting these skills?
Well, the tech and practice course starts tomorrow. There is a lot of it, and you know, Michael's here. The school is really doubling down and focused on this, and we'll have a lot more resources, I think, in the years to come. But I think again, there are tons of, you know, whenever I'm presenting to groups, I always give them a list of books, and mind you, the books get out of date pretty quickly. But you know, articles. There's a number of blogs you can follow, and some of them are more focused on the sort of practice side of it. But again, you know, there's a lot of available courses you could take. I think Harvard has a couple. I think other schools have a couple that you can do online courses and using AI for lawyers. There's lots of ways that are inexpensive to educate yourself about it. And I think, you know, for those of us who are nerdy enough to be interested in it, there's sort of, yeah, it's just a secret. Lots of information out there, and there are some really great sources that you can follow and read. So there is too much information, and you know, what was relevant and the sort of articles and cases that were relevant 2 months ago have all changed. You know, there's a decision on the Ross Intelligence and Thomson Reuters case, I think, just last week, about the use of head notes from TR to turn them into technology. So it's hard to keep up, but there's lots of ways to keep educated.
I would say play with the available tools. You know, get online those that are either paid or publicly available, and you know, work on, you know, preparing your prompts. Read the literature around what it takes to make a great prompt. There's quite an art in it. Yeah, so understanding kind of, you know, whether it's a 5 Ps or the clear framework or whatever it might be, just looking at that and understanding, okay, to get the information that I need. I need to set the context. I need to explain what this is for. This is what I'm looking for in terms of an answer. A single line question prompt is not going to get you the best case result that you need. So that in itself is a skill. So, I'd like to see the universities kind of encourage that development, because that's the reality, that people within the firms, within the profession, are learning all of this stuff now. Some of them are obviously more advanced at it than others, but the new generation of lawyers coming in needs to have those skills, because the technology's not going away. I'd say from a university perspective, my observation is that there's some variance between, you can use AI and you can't use AI, and somewhere in between that, I'd like to see students be asked to, here's a question, tell us what your, Gen AI output is, and then go away and supplement that, so that students can learn that whatever gets spat out of ChatGPT or whatever it is not a finished product. It answers the blank page question, just populating words, but there's so much more human in the loop and work that's required to finesse, questions around a legal issue, and learning that skill and the ability to do it. So,
and the flip side of that is, if you write something, some of these tools are really good at proofreading it for you, seeing if your tense is, your grammar is correct throughout it, seeing if there's a better way, it'd be like a thesaurus on steroids. So the other piece of that is, once you've written something, rely on these tools to help you just make your writing a little bit better.
yeah. So please summarize what I've just written, and if it highlights all these random points that weren't actually important in the grand scheme of things, then you need to go back to your base document and rework it, because your message is not getting across. So, you're right, using it both ways is incredibly useful.
It's really good at meeting word counts, for example.
Just FYI. I spoke on a panel previously with somebody who's written a few books on this, and he was explaining, I need to write an email to somebody, I'll put in a couple of dot points of what it needs to hit. ChatGPT will, or I use Copilot, so Copilot's going to give me a very nicely worded, sometimes overly polite, email response, which then goes to somebody who uses Copilot to summarize it, so that they know what's said. Like, the exchange of information and the use of technology, and that is getting quite wild. And, I wonder at what point we'll be able just to go back to speaking in dot points and missing that step in between. But yeah.
When I think of the role of universities in teaching on this topic, I think teaching technological competence needs to be a bit broader than AI acclimatization, and AI familiarity. That if we want to have meaningful tech competence, not just for law students, but for young lawyers, I think that requires like a broad-based education in kind of how these tools are built, but the foundational technologies that they're predicated upon. So like understanding the difference, for example, between unsupervised machine learning and deep reinforcement learning, and why would it matter that the model you're using, why would it matter what it's built on? That makes a big difference, right, in terms of its reliability and what it's able to do. Just understanding conditional logic and maybe challenging yourself to learn a little bit of code, God forbid. That I think that like a broad-based approach to teaching tech competence is how we kind of develop a muscle, and again, using that analogy, like getting rid of those blind spots for when we're relying on these tools, so that we have the magnifying glass that we need to actually see like what's actually going on, is what I was thinking.
I think that your comment around, learning how these things are built, certainly now with the movement towards document automation within the practice of law, there's a whole bunch of no-code solution, but still the logic in if this, then that, in terms of drafting contracts or other documents, requires some intellectual rigor to be doing that. So the more that you understand it, we'll soon come to a world where, I hope it's really, really soon, I never have to read an NDA again, and certainly don't need to prepare one because, you know, that's certainly not worth my charge out time. But, you know, we've now got technology where you can just enter into a few variables, you know, parties' details, what information is being exchanged, what's the purpose, and it's going to spit you out a perfectly good non-disclosure agreement, much better than you'll get from ChatGPT, based on what I've seen people send me. But, you know, understanding how all of that works and having some ability to be developing and understanding how document automation works and the role that that's going to play. You know, 5 years ago, all we heard about was blockchain and smart contracting, and that's kind of gone a bit silent recently. But, you know, there's still an application of that within the profession.
Yeah, I think if we overemphasize like results in terms of teaching tech competence, so like look at what these tools can do, look at the result, and we don't focus enough on process, that we're not really teaching meaningful skills that can be applied critically in the future. And so I just really think that we need to make sure we're giving people the tools to critically analyze what these systems are doing.
I think at its base, you know, being a lawyer is just about having a really good problem-solving skill set, and you know, the technology is not going to be it. It's not going to take that away if you can't logically draw the connections between various things. You know, that's a challenge.
Thank you. We have a little bit of time, so I kind of wanted to open up to the audience and see if anyone had questions that they'd like to ask. Yeah, go ahead.
First of all, I'd like to make a comment to your question. You can start actually learning what AI is a student or prof within the community at Dell. We have a Bright Space course that's the ADA across that computer sciences is the university lead on the AI strategy for the wrong venue for the university. And it's a basic introduction to AI, and it talks about prompt writing as well as using it in that.
That's great.
Thank you. My field is privacy and AI, by the way, and really good to hear you both talk human in the loop. But where do you see the field, and it is a new field now, of prompt engineering? Does it sit with, and should it be taught by the law school for lawyers, or does it sit with the venue of the legal paralegals? So more of a trade type of competency, and then also if you could tie that in with the accountability of lawyers to be that human in the loop, to be accountable to verify.
So it sounds like a lawyer answer, but both, and it depends.
But I think the reason for that is if you look at the role of a paralegal, for example, the lawyers still need to supervise and know what the paralegal is doing. And I think, even though I think there's a debate about whether lawyers need to be coders, I think prompt engineering is sort of an outgrowth of Boolean searches from the early days of quick law, for example. It's important. You might not be sort of an expert at it, but to me, it's not necessarily a separate discipline. It's how you leverage your knowledge of and access to these tools to get the answers you know that you want. Some people are a lot better at it. We have legal engineers who do some of this work and software engineers, and they're much better at it, but they don't know the nuances of the practice, or you know how you determine whether an NDA is still valid. It's usually just a thing that says expires in 3 years or continuing obligations. So you can't just have a sort of mathematical formula for some of that stuff. So I think it's incumbent upon all of us who use or rely on the output from these tools to understand that. I was reading something yesterday about whether prompts are going to become discoverable, for example, in litigation. And I was a bit mortified, but then I realized, again, to take it to the e-discovery context, you exchange lists of keywords that you used to search databases to get the information. So to me, we've just moved from keyword or Boolean searches to prompts, and I think everybody needs to know. That's mine. You guys may feel different.
No, I agree. And, you know, I think the benefit, I work very closely with our Chief Technology Officer, and I trial certain types of legal specific software because I know the keywords that I need to be using, the questions, the context that I need to provide, that somebody that doesn't have that legal knowledge doesn't necessarily know or understand. So, it's asking one question and then well, what about this? Well, then that's contrary to that, following that chain of questioning that doesn't come up always the first time round. So I do think it's incumbent on anybody that's using the technology to understand how to use it to
And vice
most
versa,
effect.
the lawyer should be able to understand the technology then as
To
well.
some extent, for sure, yeah.
My initial response, Carla, to your question is like, I kind of hope that law school doesn't become prompt engineering in 5 years. And I hope that, to use the analogy from Sobeys, we're not the one employee that watches the 10 self-checkout machines. That's the job of a lawyer. Right? I hope that there's still room for humanity in that.
Unlike with other skills, some people will be really good at it. It's like document automation. In the early days of document automation, the sort of decision trees around the generation process, some people just weren't very good at that because it's like logic. It's like doing the LSAT all over again, day after day. And so some people will just develop specializations or just be better at it.
I also think that it opens up opportunities within the profession for people to be going into, legal operations or legal design and, all these professions that never existed 10 years ago. It's broadening. If you've got skill sets and interests beyond strictly practicing law, the opportunities are now huge for you. So, and I think that's exciting for the profession.
Yeah, well, I just want to piggyback on some of the comments. Really not one who states in the room for practicing for a very long time. I think one of the cautions to using this tool, which can be used in so many creative and very assistive ways, is that young lawyers new to the profession have a lot of pressures on them to produce quickly, and they may see this as the go-to to do that, and in doing so, they, with all respect, they don't have the experience to be able to identify when it is just wrong, the information they're getting, or when you talked about before, between the misleading information you might get. They may think it sounds good, they may pick a case and look it up and say it exists, but they don't really have the skill set at that point to make that determination. And what they're doing is they're putting their professional reputation on the line. So as wonderful as a tool it is, I would suggest that you tread carefully and use it as the three of you have suggested as a support. If you don't know how to research, and I was from the books in the library to the learning about Westlaw, Quick Law, to learning about Canley, and as an older lawyer, it's harder and harder and harder to do it. But I feel that I have the skill set, so I started playing with AI, and I can tell you the first time I ran some stuff through, what came back was dead wrong. And if I hadn't known just by looking at it that this isn't possible, I could have written a paper on something that was completely false. So just a caution, supporting what you're saying, that just as young lawyers, be super careful. You don't get caught up in the fast and the quick and the easy, because it's your reputation, and the last thing you want to be doing is saying to a client or whoever you represent that, oopsie, that was all wrong.
Sorry, what was your name?
Paula Arrow.
Paula, yeah. So I think your comment also speaks to the importance of the articling student and principal relationship, right? And that if these tools are going to be more commonplace, and if clerks are going to feel, or young lawyers are more reliant to produce documents with them, then this increases the importance of that relationship and that supervision. And so I think we really need to be careful about neglecting the importance of that relationship. And I know there have been alternative models produced in other provinces, and there's all kinds of discussions about what to do about that. But I think there's maybe some need to kind of preserve the sanctity of the articling clerk principal relationship, so that there is actually a real apprenticeship. And there's a reason we decided to make the practice of law start with that, right? There's a reason, because that's the way that real skills the know-how, not just the know what, but the know-how
Exactly.
gets translated, right?
Exactly.
Yeah.
AI is not your mentor. It's not. AI is not teaching you. You have to be able to know what to put into AI to generate the information you need. So sometimes it's only as good as what you put into it. And if you don't have a skill, build a skill to know what, it's like using, for those who ever still use QuickLaw, I don't even know. QuickLaw is almost impossible because unless you put in the right words, you wouldn't get any of the case, you come back with no cases and you're thinking there's gotta be a case on this, right? So you have to know what to put in order to generate the correct output.
And I do think that that's, a big risk, certainly at Cox and Palmer. We trial it with experienced lawyers, mostly partners who can distinguish, between this is accurate content and this is not. So just deploying technology like that widely to all the brand new lawyers, it's almost a recipe for disaster because, again, you don't want the AI training your lawyers. But there's also needs to be a recognition that whatever I pump out reflects on me and my professional competence. And, I'll give you an example of a client-facing work that I did, a consultant who wanted to use AI in, the provision of their services, and the customer of that came to me with, yeah, that's okay, we recognize that there are some issues around and we'll accept that. But you're paying these people to provide a specialist skill. If they use AI or not and AI gives them a rubbish result, they need to stand by that. And, that can't be stressed enough. Nobody again wants to be that lawyer that is in front of the judge with the arsenal of hallucinated cases they're trying to argue. It's poor practicing.
Well, I think that's all the time we have for this first panel. Thank you, Carla, Jane, and Anthony, for your time, sharing your insights. It's a really exciting and new topic, and I'm glad to be a lawyer in this day and age where I can kind of fact check, but not really, against AI. We're going to take a quick break and set up our second panel, which is Regulation, the Future of Legal Profession. Thank you.